Chapter 63, Incest. Section 790. Definition. Incest is carnal connection between a man and woman linearly related to each other, or collaterally related in such a degree that marriage between them is prohibited by law. It is said that this, like adultery, was an offense punishable only by the ecclesiastical law, not by the common law. Since the degrees within which marriage is permitted are regulated by statute, and vary in different jurisdictions, it has been held necessary to show that the parties are not married, for if contracted out of the state, the marriage might be valid. The statutory relationship includes illegitimate kinship, and kinship by the half-blood, or relationship by affinity, so as to make intercourse with a sister-in-law criminal. In other jurisdictions, relationship by affinity is not included. But a relationship dependent on marriage exists only while the marriage endures. Thus it is held there cannot be incest with a stepdaughter unless her mother is the living wife of the defendant, although other courts hold relationship by affinity continues so long as there are living issue of the marriage. Relation by marriage extends only to the spouse's blood relations, thus, one is not related by affinity to his wife's brother's wife. The reasons for punishing incest are said to be that proper propagation of the race demands parents of different families, and that the practice is contrary to natural feeling. Section 791. Elements of offense. It is as unnecessary to prove emission as in case of rape. It is usually held that mere proof of marriage is sufficient without showing carnal intercourse, and in no jurisdiction is more than one act of intercourse essential. It is usually held that the crime involves mutual consent, that both parties are guilty of the offense, and that both must be proved guilty to sustain the indictment, although both need not be jointly indicted. If the statute is so worded, the prosecution must prove that the offense was committed, knowing the relationship. Consent of the woman is not a defense, nor the fact that she is a prostitute. Section 792. Incest and rape. It is generally held that consent is necessary to incest, and that if force was used by the man, the act was rape, and there can be no conviction for incest. But there are other cases holding consent of both parties not necessary, and it is held that under an indictment for rape, where force was not shown, a conviction of incest may be sustained. If the woman be under age of consent, the offense is rape, not incest. Section 793. Corroboration of evidence of female. By corroboration is meant evidence other than that of the prosecutrix which, in itself and without the aid of her evidence, tends to connect the accused with the commission of the offense. In some states, it is not required that the evidence of the injured party be corroborated. In other states, corroborating evidence is essential. Where the evidence of the prosecutrix is contradictory, or her general reputation for truth, honesty and integrity in the community is bad, and the accused denies the accusation against him and is corroborated, evidence of the prosecutrix will not warrant conviction of incest without corroboration. Section 794. Weight and sufficiency of evidence. Where the evidence of the female is corroborated, and there is positive evidence of the defendant's guilt, a new trial for insufficiency of evidence will not be granted although it is conceded that the prosecutrix is an accomplice. In the prosecution of a father for incest with his daughter, evidence of her mental attitude toward him and conduct goes only to the weight and credibility of her evidence as tending to show a motive to falsify and does not destroy its probative force.